Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only. The information provided here does not constitute legal, financial, or professional advice. Divorce laws vary significantly by state and jurisdiction, and the concepts discussed regarding online divorce education platforms are based on historical trends and case studies, rather than individual legal counsel. You should always conduct your own due diligence and consult with a licensed attorney or a qualified professional before making any decisions that could impact your legal or financial status. The American dream has a hidden price tag, and for millions of people, that price is exactly $50,000. That is the average cost of a contested divorce in the United States when you factor in legal fees, asset liquidation, and the loss of shared equity. But while the traditional legal system has remained a slow-moving, expensive machine for decades, a new disruptor has emerged in the digital landscape: the divorce university. Right now, thousands of Americans are skipping the traditional law office waiting room and are instead enrolling in online universities designed to teach them how to navigate the end of their marriage like a business transaction. We are witnessing the commoditization of heartbreak. In an era where you can learn to code, trade stocks, or build a house via an online course, the Divorce University has become the ultimate survival guide for the modern demographic. But is this a revolutionary democratization of the legal system, or is it a high-stakes gamble with your future? Today we are going deep into the mechanics of these platforms, the specific U.S. demographics they are targeting, and why the family court grinder is being bypassed by a new generation of digital-first litigants. By the end of this deep dive, you will understand the structural shifts in American domestic law, the economic reality of the pro se movement, and the exact strategies these platforms use to help people protect their assets and their sanity in a system that often seems designed to drain both. To understand why these online divorce universities are exploding in popularity, we first have to look at the historical trends of the American household. For decades, the legal process of ending a marriage was shrouded in mystery, accessible only to those who could afford a high-retainer attorney. The system was built on a perpose basis until the late 1960s, meaning you had to prove someone was at fault to get out. When California passed the first no-fault divorce law in 1969, it triggered a massive demographic shift. Suddenly, the why didn't matter as much as the how. However, the legal industry didn't get any cheaper. In fact, as the complexity of assets grew, think 401ks, stock options, and digital property, the cost of litigating a divorce skyrocketed. This created a massive gap in the market. There was a huge demographic of middle-class Americans who earned too much to qualify for legal aid, but not enough to spend $60,000 on a multi-year court battle. Enter the digital education boom. We are currently living through what sociologists call the information age of litigation. Modern U.S. demographics, particularly millennials and Gen X, are characterized by a high degree of digital self-efficacy. This means they are used to solving complex problems via search engines and structured online learning. When these individuals face a life crisis like a divorce, their first instinct isn't to pick up a phone and call a law firm. It is to open a laptop. Online divorce universities have capitalized on this by offering curriculums that break down the terrifying, jargon-heavy world of family law into manageable modules. They offer potential outcomes based on historical case studies, templates for financial affidavits, and strategic frameworks for mediation. But who exactly is the target audience for these platforms? The data shows a fascinating trend. We are seeing a rise in what is known as the gray divorce among those over age 50, as well as a significant shift in how younger couples approach the end of a relationship. For the silver splitters, the primary concern is the preservation of retirement assets and the navigation of complex alimony laws that have changed significantly in the last decade. For the younger demographic, the focus is often on co-parenting algorithms and the division of non-traditional assets like cryptocurrency or side hustle businesses. These online universities are tailoring their content to these specific niches, offering tracks or majors, depending on the complexity of your household. Let's look at the economic case study of a standard U.S. divorce. In a traditional setting, every email to an attorney, every phone call, and every minute spent in a waiting room is billed in 6-minute increments. A single contested motion can cost thousands of dollars before a judge even hears the first word. The divorce university model flips this on its head. By paying a flat fee for access to a library of educational content, the user is essentially insourcing the paralegal work. They are learning how to fill out their own forms, how to calculate their own child support based on state guidelines, and how to present themselves in a mediation setting without an attorney billing them for every breath. This isn't just about saving money, it's about a shift in the power dynamic. It is the transition from being a client to being an informed consumer. However, we must analyze this through the lens of modern U.S. demographics and the risks involved. The legal system is not a static entity. It is a living, breathing ecosystem that varies by county, not just by state. One of the biggest challenges identified in historical trends is the pro se bottleneck. When people use online tools to represent themselves without a deep understanding of local court rules, they often run into procedural walls. This is where the advanced modules of these divorce universities come into play. They don't just teach the law, they teach the metagame. They provide insights into how to manage the emotional volatility of the process, how to communicate through parenting apps, to create a paper trail that is court admissible, and how to negotiate using game theory principles rather than emotional outbursts. This brings us to the productization of trauma. We are seeing a massive shift in the U.S. economy where personal crises are being rebranded as educational opportunities. The Divorce University is part of a larger trend of life event tech. Whether it is planning a wedding, managing a death in the family, or navigating a divorce, there is now a digital dashboard for it. For the U.S. audience, this provides a sense of agency in a situation that usually feels completely out of control. The promise of these platforms, at least in a marketing sense, is that knowledge is a shield. They use case studies to show how a well-prepared individual can potentially reach a settlement in months rather than years. But we have to ask the hard questions. Is the modern U.S. demographic being served or being sold? As we look at the data, we see that the success of these platforms often depends on the contestedness of the case. In a low-conflict scenario, these online universities can be highly effective tools for streamlining the process. In high-conflict scenarios involving domestic issues or hidden assets, the limitations of an online course become apparent. This part of our deep dive is about understanding that boundary. It's about looking at the syllabus of separation and identifying where digital education ends and the need for high-level professional intervention begins. We are going to examine the specific lessons these universities teach, from the discovery phase to the final decree, and how the modern American is using these tools to redefine what it means to win a divorce. In the next sections, we will break down the actual curriculum used by these platforms, analyze the specific financial strategies they suggest for asset protection, and look at the psychological impact of turning a marital breakdown into a structured educational project. This is the new reality of the American domestic landscape, where the courtroom is being replaced by the classroom, and the lawyer is being replaced by the laptop. To understand the curriculum of a modern divorce university, we must first look at the psychological shift from emotional victim to strategic administrator. In 2026, the educational framework of these platforms is built around the concept of litigation readiness. Imagine a resident of a high cost of living area like Austin, Texas, named Alex. Alex is 42 years old, a mid-level software manager, and is facing the dissolution of a 15-year marriage. In previous decades, Alex would have walked into a law office, handed over a $5,000 retainer, and waited for instructions. Today, Alex logs into a portal that looks more like a high-end corporate training platform than a legal service. This is the first module of the Divorce University, the architecture of information. These platforms operate on the historical trend that the person with the best organized data typically sees more favorable potential outcomes in mediation. The curriculum begins with a deep dive into the financial affidavit, often called a statement of net worth. In 2026, this is not just a form. It is a complex data mapping exercise. The university teaches Alex how to categorize every single asset into one of two buckets: separate property or community property. Historical trends in states like Texas or California show that the misclassification of assets is the leading cause of prolonged litigation. Alex is taught to hunt for transmutation. This is a key legal concept where separate property, such as an inheritance Alex received 5 years ago, may have been commingled into a joint savings account used to pay for a kitchen remodel. The university provides a step-by-step audit process, showing Alex how to pull bank records from 2021 to 2026 to prove the original source of the funds. This level of granular detail is usually where a traditional paralegal would spend 20 hours of billable time. By doing it himself through a guided module, Alex is effectively reducing his future legal fees by thousands of dollars before he even files a petition. The 2026 demographic of Divorce University users is increasingly composed of what we call the digital native litigant. These are individuals who are comfortable using AI-assisted tools to scrub through 5 years of Amazon purchase history to establish a standard of living report. This is a critical component of the curriculum. In the U.S. legal system, alimony or spousal support is often calculated based on the lifestyle maintained during the marriage. These online platforms provide templates that allow Alex to calculate the exact cost of his household's monthly burn rate, including everything from streaming subscriptions to the fluctuating cost of grocery delivery, in 2026. By presenting a data-backed standard of living report, Alex moves the conversation from emotional arguments about what is fair to a mathematical discussion about what the data shows. Case studies within these universities often highlight the discovery phase as the most dangerous part of a divorce. This is the legal process where both parties must swap all financial cards on the table. In a traditional divorce, this is a hostile exchange of boxes and encrypted files. The Divorce University model teaches a proactive discovery strategy. The lesson plan involves creating a virtual data room. Alex is instructed to upload every tax return, W-2, 1099, and 401k statement into a secure, organized folder structure. The university provides a checklist of over 200 items, ranging from the obvious, like the deed to the house, to the obscure, like frequent flyer miles, credit card reward points, and the vesting schedule of stock options. In 2026, many employees in the tech and medical sectors have complex compensation packages that include restricted stock units or RSUs. The university curriculum includes a specialized module on how to read a grant agreement to determine which portion of those stocks was earned during the marriage and which portion is a future incentive that might be protected as separate property. Another major demographic shift we are seeing in 2026 is the rise of the creator economy divorce. Imagine a couple where one spouse is a full-time content creator with a significant following. How do you value a YouTube channel or a TikTok account? Traditional law has been slow to catch up, but the Divorce University curriculum is nimble. They provide case studies on intangible asset valuation. Students are taught how to look at historical trends in monthly ad revenue, brand deal contracts, and the goodwill value of a digital brand. They are taught to treat the brand as a business entity, requiring a formal valuation rather than just looking at a bank balance. This prevents one spouse from being undercompensated for a business they helped build behind the scenes, or conversely, prevents the creator from being overcharged for a platform that has a high degree of volatility. The university also tackles the psychology of negotiation. In Part 1, we mentioned the BIF method: brief, informative, friendly, and firm. In this second part of the curriculum, students engage in simulated mediation. They are given scripts and scenarios. For example, if the opposing party makes a high-conflict demand regarding the primary residence, the student is taught to use decoupling tactics. This involves separating the emotional value of the home from its equity value. The curriculum teaches Alex to calculate the cost of sale and the capital gains tax liability that would occur if the house were sold in the 2026 market. By showing these figures to the other spouse, Alex can often demonstrate that keeping the house might actually be a financial liability rather than an asset. This shift from, "I want the house" to "let's look at the tax-adjusted equity" is a hallmark of the Divorce University approach. Furthermore, we must look at the gray divorce demographic, individuals over 50 who are ending long-term marriages. For this group, the Divorce University offers a Social Security and Pension Masterclass. In the U.S., if a marriage lasts more than 10 years, a spouse may be entitled to a portion of the other's Social Security benefits without reducing the original holder's amount. Historical trends show that thousands of Americans leave this money on the table because they simply don't know the rule exists. The university curriculum ensures that this demographic understands the 10-year rule and the mechanics of a QDRO, or Qualified Domestic Relations Order. A QDRO is a specialized legal document required to split a retirement account without triggering massive tax penalties or early withdrawal fees. In a traditional divorce, an attorney might charge an extra $1,500 just to outsource this document to a specialist. The Divorce University teaches the user how to obtain the plan administrator's pre-approved template, saving time and ensuring the division is handled correctly. As we analyze these modules, it becomes clear that the Divorce University is not just a collection of videos. It is a legal project management system. It treats a divorce like a corporate merger or a bankruptcy restructuring. It removes the soul of the conflict to save the substance of the estate. But as Alex moves through the modules, he encounters the most difficult semester of all: the child custody and co-parenting algorithm. In 2026, U.S. courts are moving toward 50/50 as the default starting point, but the implementation is where the conflict lives. How do you manage a schedule when both parents work hybrid roles? How do you handle right of first refusal in an era of gig economy childcare? The university doesn't just give advice, it provides parenting plan builders that generate court-ready documents based on the specific zip code's local rules. This brings us to a critical junction in our deep dive. While Alex has saved $10,000 in prep work, he is now entering the battle of the experts. In a high-asset 2026 divorce, it is not just about the forms, it is about the valuation. And there is one asset class that is currently causing more chaos in American family courts than anything else, a topic that even the most advanced divorce universities struggle to simplify. It is the world of hidden digital wealth and asset dissipation. If Alex's spouse has been moving funds into decentralized finance protocols or offshore digital vaults during the last 3 years of the marriage, a simple bank audit won't find it. The question then becomes, can a digital university teach a layperson how to perform forensic digital accounting? Or are there some walls that even the best online education cannot climb? In the next part, we are going to look at the dark side of discovery, how the 2026 Divorce University teaches students to spot red flags of asset hiding, and the specific case studies of marital waste that are currently reshaping U.S. case law. We will explore what happens when the educational model meets a hostile actor who doesn't want to play by the rules of the syllabus. In the world of the 2026 Divorce University, the transition from administrative organization to forensic investigation is where the stakes escalate from mere paperwork to financial survival. We must now look at the case of Sarah, a healthcare administrator in Seattle. Sarah has been married to her spouse, a freelance consultant, for 12 years. Over the last 18 months, she noticed their joint savings account stagnating despite a significant increase in her spouse's project load. In a traditional 20th century divorce, Sarah might have simply suspected an affair or poor spending habits. But in 2026, Sarah is enrolled in an online divorce masterclass that has taught her to look for something much more calculated: asset dissipation, also known as marital waste. Marital waste is a legal concept that refers to the intentional depletion of marital assets by one spouse for a purpose unrelated to the marriage, typically occurring when the relationship is breaking down. The Divorce University curriculum for 2026 provides a forensic-level deep dive into this phenomenon, teaching students that they don't necessarily need a $10,000 forensic accountant to find the first clues. The university provides Sarah with a step-by-step audit framework titled the Red Flag Matrix. This matrix focuses on historical trends where spouses utilize modern financial friction to hide wealth. The first step Sarah is taught is the analysis of the lifestyle spike versus income plateau. The university provides Sarah with a spreadsheet template where she inputs 5 years of their joint tax returns and bank statements. In 2026, many of these platforms offer an automated scan feature that uses pattern recognition to flag anomalies. Sarah's scan flags a series of recurring $500 transfers to a digital payment platform she doesn't recognize. To a layperson, these might look like small, insignificant expenses. To a divorce university student, these are breadcrumbs. The curriculum explains that in many U.S. jurisdictions, if Sarah can demonstrate a pattern of non-marital spending, such as transfers to a hidden investment account or gifting money to a family member with the intent of retrieving it post-divorce, she may be entitled to a reconstitution of the marital estate. This means the court could potentially credit Sarah with half the value of that wasted money as if it still existed in the bank account. But how do you prove intent in 2026? This is where the university's module on digital forensics for the pro se litigant becomes essential. Sarah is taught about the timestamp correlation method. The university instructs her to cross-reference the dates of those $500 transfers with her spouse's travel calendar or communication logs. Historical trends in family law suggest that asset hiding often correlates with the decision point, the moment one spouse decides to leave but hasn't yet informed the other. By mapping out this timeline, Sarah builds a case study of her own marriage, showing that the financial leaks only began once the relationship soured. The complexity of this increases exponentially when we enter the realm of decentralized finance or DeFi. In 2026, the U.S. demographic of high-earning professionals often has a portion of their wealth in digital assets. A common tactic for a hostile actor is to move liquid cash into a cold storage hardware wallet or an offshore digital vault. The Divorce University doesn't give Sarah a how-to on hacking. Instead, it teaches her how to follow the exit ramps. This involves looking for transfers from a traditional bank account to a known crypto exchange. Once the money hits the exchange, it might disappear into a private wallet, but the initial transfer remains on the bank statement. Sarah learns that the exchange log is a discoverable document. The university provides her with a template for a request for production of documents specifically tailored for digital assets. This template demands not just the current balance, but the entire transaction history and a list of all public keys associated with the spouse's accounts. Imagine if Sarah had tried to do this without a structured curriculum. She likely would have been overwhelmed by the technical jargon or dismissed by an overworked court clerk. Instead, the online university provides her with a motion to compel discovery template, pre-formatted for her specific county in Washington state. This allows her to present a professional, data-backed argument to a judge, explaining exactly why her spouse's claim of market losses doesn't align with the historical trends of the accounts in question. Beyond the digital trail, there is the issue of the friendly debt. This is a classic case study taught in these universities. A spouse suddenly borrows a large sum of money from a parent or a close friend, claiming it's for a business emergency, and signs a promissory note. In reality, the spouse is just parking marital cash with a co-conspirator. The 2026 Divorce University curriculum teaches students how to challenge the validity of these debts. Sarah is taught to look for the 4 pillars of a sham loan. Is there a market rate interest? Is there a repayment schedule? Has any collateral been pledged? And most importantly, was the money actually spent on a marital purpose? By providing Sarah with the specific questions to ask in a deposition, the university empowers her to expose the debt as a fraudulent transfer. We must also consider the small business trap. Many U.S. demographics in 2026 are part of the 1099 economy, meaning one or both spouses might own a small LLC or a consulting firm. This is the ultimate playground for asset hiding. A hostile spouse might prepay vendors for services to be rendered in 2027, or they might delay invoicing clients until after the divorce decree is signed to make their income look lower than it actually is. The Divorce University's business valuation track teaches Sarah how to look for accounts receivable and deferred revenue. She learns that her spouse's income isn't just what is on his W-2. It is the total distributable cash flow of the business. This level of depth is what makes these platforms viral. They offer a sense of control in a situation where the other party is actively trying to gaslight the victim about their financial reality. However, the university also provides a sobering lesson on the cost-benefit analysis of conflict. Sarah is taught that while she might find $5,000 in hidden assets, spending $10,000 in legal fees to recover it is a net loss. The curriculum emphasizes strategic settlement, using the evidence of hidden assets as leverage in mediation, rather than as a weapon in a courtroom. By showing her spouse that she has the receipts, literally, Sarah can often bypass a trial entirely. As we analyze Sarah's journey through the forensic module, we see a shift in the American demographics approach to justice. It is no longer about winning through emotional testimony. It is about winning through superior data management. But there is a ceiling to this self-taught forensic approach. What happens when the hostile actor is not just a spouse with a laptop, but someone with a sophisticated network of offshore entities and shadow accounts? What happens when the education provided by the Divorce University hits a wall of institutionalized secrecy? This leads us to the most contentious and emotionally charged part of the entire 2026 Divorce University curriculum. While Sarah has been focused on the money, the clock is ticking on an even more complex calculation. It's the module that every student hopes they don't have to master, but most eventually do. We are moving from the ledger of assets to the ledger of time. In the next part, we are going to dive into the custody algorithm, how modern U.S. courts in 2026 are using automated software to determine parenting time, and how divorce universities are teaching parents to optimize their digital footprints to influence these judicial machines. We will explore the social media audit that can make or break a custody case before the first hearing even begins. Are you prepared for how your 2024 posts might dictate your 2026 parenting schedule? The transition from the ledger of assets to the ledger of time represents the most emotionally volatile shift in the Divorce University curriculum. In 2026, The American legal landscape has moved away from the subjective gut feelings of individual judges and toward what sociologists call the datafication of parenting. To understand this, we must look at the case of James, a project lead for a logistics firm in Columbus, Ohio. James is a father of two, ages 8 and 10. He is entering a 2026 divorce believing that his history as an involved father is obvious and undisputed. However, the Divorce University curriculum for Part 4, titled The Digital Parent Audit, immediately challenges this assumption. The curriculum begins with a sobering reality check. Your smartphone has been a silent witness to your parenting for the last 5 years. And in 2026, that witness is being subpoenaed by the algorithm. James discovers that in many U.S. jurisdictions, the best interests of the child standard is now augmented by a suite of evidentiary tools that family law practitioners and pro-se litigants use to quantify parenting time. This is often referred to as the stability index. The university teaches James that he cannot simply walk into a mediation room and claim he is a hands-on dad. He must prove it through what the curriculum calls passive data evidence. This starts with a deep dive into the Google Maps timeline and Apple location history from 2024 and 2025. Imagine James is in a dispute over whether he consistently attended his daughter's gymnastics practices or his son's soccer games. His ex-spouse's attorney might claim he was a no-show father during the critical years leading up to the separation. The Divorce University provides James with a step-by-step technical guide on how to export his location data and cross-reference it with the GPS coordinates of the gymnastics center and the soccer fields. By filtering for Tuesday and Thursday afternoons between 4 p.m. and 6 p.m. for the years 2024 and 2025, James can produce a heat map of his physical presence. Historical trends in 2026 show that courts are increasingly receptive to this kind of forensic location data, because it is much harder to manipulate than a handwritten diary or a self-serving testimony. The university provides a template for a presence report, which transforms these GPS pings into a professional visual aid for the court. But the audit does not stop at physical location. The next module focuses on digital domesticity. In the modern U.S. demographic, parenting is measured in transactions. Who bought the school supplies? Who ordered the size 4T diapers in 2024? Who paid for the orthodontist appointments in 2025? The Divorce University curriculum teaches James how to aggregate his Amazon, Instacart, and DoorDash records. By exporting these CSV files and running them through the university's categorization script, James can build a physical care ledger. If James can show that 70% of the children's clothing and educational materials were purchased through his individual accounts over a 2-year period, he creates a powerful rebuttal to the narrative that he was a peripheral parent. This is a case study in using the 1099 economy tools to defend one's role in the domestic sphere. Then comes the most dangerous part of the curriculum: the social media spoliation warning. This is where many 2026 litigants fail before they even start. James might be tempted to go back to his 2024 Instagram or Facebook feed and delete photos that might look bad in a custody evaluation. Perhaps a late-night party with coworkers or a venting session about his spouse in a private group. The Divorce University warns that in 2026, deleting this data after a divorce has been contemplated can be flagged as spoliation of evidence, leading to a negative inference by the judge. Instead of deleting, the university teaches narrative reframing and contextualization. The curriculum provides an audit for optical inconsistency. James is instructed to look at his 2024 posts through the lens of an opposing attorney. Does his feed show a high-spending, party-oriented lifestyle while he simultaneously claims in court that he cannot afford increased child support? The university teaches him to find the counter-evidence. If there is a photo of him at a music festival in 2024, he must find and timestamp the photos of him at a school play or a doctor's visit from the same week. The goal is to demonstrate a balanced lifestyle rather than a curated or inconsistent one. The university even provides a module on EXIF data, the hidden metadata inside digital photos. James learns that every photo he took of his kids in 2025 contains a GPS coordinate and a precise timestamp. The curriculum shows him how to map these photos onto a calendar to prove he was present during holidays and birthdays that the opposing party might claim he missed. As James moves deeper into the 2026 curriculum, he encounters the algorithmic mediation module. In the United States today, parenting apps like Our Family Wizard or Talking Parents have become standard court-ordered communication tools. However, in 2026, these apps have integrated advanced AI sentiment analysis. When James types a message to his ex-spouse saying, You are always late and it is ruining the kids' schedule. The app's AI might flag that as high conflict language. The Divorce University teaches James the BIF method again, brief, informative, friendly, and firm, but specifically tailored for an AI-monitored environment. He is taught to write every single message as if a judge or a child custody evaluator is reading it in real time. The curriculum emphasizes that in 2026, your communication score within these apps can directly influence the parenting time delta. Furthermore, the university addresses a growing demographic trend in the US, the influence of the third-party digital footprint. This refers to what other people post about you. James is taught how to monitor the social media of his friends and family. If his brother posts a video of James at a 2025 New Year's Eve party where James appears intoxicated, that video can be used against him in a custody hearing. The university provides a digital conduct agreement template that James can give to his inner circle, politely asking them to refrain from posting images of him or the children during the duration of the legal proceedings. This is the 2026 version of operational security for the American family. We must also look at the case study of Maria, a mother in Phoenix who used the Divorce University's school and medical portal audit to secure her 50-50 custody. Maria's ex-husband claimed she was disorganized and unfit for a shared schedule. Maria used the university's techniques to pull logs from the school's parent portal and the pediatrician's digital chart. These logs showed that Maria was the one who logged in to check grades 90% of the time and was the primary contact for every medical appointment in 2024 and 2025. By presenting this digital involvement audit, Maria moved the case away from he said, she said, and toward a data-backed reality of parental responsibility. But here is the catch that the Divorce University saves for the end of the module. The custody algorithm is not just about where the children sleep. It is a direct input for the child support formula. In the modern US demographic, time is literally money. In many states, reaching a specific threshold of overnight stays, such as 128 nights per year, triggers a massive shift in the child support calculation. This creates a high-stakes environment where every single day on the calendar has a dollar value attached to it. If James can prove his historical involvement through the data we just discussed, he isn't just fighting for his relationship with his children. He is fighting against a potential financial cliff. The Divorce University reveals that the math of fatherhood is more complex than anyone realizes. But what happens when the math doesn't add up? What happens when one spouse's income is artificially suppressed or hidden behind the gig economy or digital side hustles we mentioned earlier? In the next part, we are going to look at the child support hack, a deep dive into how divorce universities teach students to navigate the income shares model, calculate imputed income, and find the extraordinary expenses that can swing a support order by thousands of dollars a month. We are going inside the hidden spreadsheets of the U.S. family court system. The mechanical heart of the American family court system is often found in a series of complex, state-mandated spreadsheets known as the Child Support Guidelines. To the uninitiated, these look like simple math problems, but to a student of a 2026 Divorce University, they are a high-stakes arena of financial engineering. In the modern U.S. demographic, where income is no longer just a steady bi-weekly paycheck, understanding the nuance of these calculations is the difference between a sustainable future and financial insolvency. Let us examine the case of David, a senior marketing consultant in Charlotte, North Carolina. In 2024, David was earning a base salary of $140,000 with a performance bonus structure that could reach an additional $40,000. By 2026, as his marriage reached its final stages, David transitioned into a freelance consulting model, reporting a fluctuating income that averaged only $90,000. This is where the Divorce University curriculum introduces its most critical concept, imputed income. In the eyes of the court in 2026, your income is not necessarily what you are currently earning. It is what you have the capacity to earn based on your education, historical trends in your career, and the local job market. The university teaches that if David voluntarily reduces his income to lower his support obligation, the court can impute income to him at his 2024 levels. David's curriculum involves a step-by-step deep dive into the vocational evaluation. This is a process where a professional expert analyzes David's resume, his 2024 and 2025 tax returns, and current job postings in the Charlotte area to determine his true earning potential. The university provides David with historical case studies showing that unless he can prove a legitimate reason for his income drop, such as a health condition, a regional industry collapse, or a documented layoff, the spreadsheet will likely reflect the higher number. To counter this, the university teaches David how to build a rebuttal of earning capacity. This involves documenting every job application, every rejection letter, and every shift in market demand since 2025. If the marketing sector in 2026 is seeing a downturn due to automation or AI integration, David must present this data as a historical trend rather than a personal choice. The goal is to move the judge from a mindset of David is hiding money to David is adapting to a shifting economy. This level of preparation is what separates a pro-SE litigant from a victim of the system. Next, the 2026 curriculum focuses on the income shares model, which is used by the majority of U.S. states. This model operates on the principle that the child should receive the same proportion of parental income that they would have received if the parents were still living together. Imagine if David and his ex-spouse, Sarah, have a combined monthly adjusted gross income of $15,000. The state provides a schedule of basic child support obligations, a literal table that says for 2 children at this income level, the basic support amount is, for example, $2,400 per month. The university teaches David how to calculate his pro rata share. If David earns 60% of the total income, he is responsible for 60% of that $2,400. However, the basic obligation is just the starting point. The 2026 Divorce University identifies what it calls the silent support killers: healthcare premiums, work-related childcare costs, and extraordinary expenses. In the modern U.S. demographic, childcare in 2026 can often exceed the cost of a mortgage. The university instructs David to perform a 2025 to 2026 childcare audit. He must obtain the actual tax ID of the provider and verify the exact monthly cost, ensuring that any government subsidies or tax credits Sarah receives are deducted from the total before his percentage is applied. Historical trends show that many parents accidentally pay a percentage of a gross childcare bill, forgetting that the other parent is receiving a significant child care tax credit at the end of the year. Then there is the issue of extraordinary expenses. In 2026, this doesn't just mean private school or orthodontics. It now includes things like high-level club sports, specialized tutoring, and even digital subscriptions required for education. The university teaches David the opt-in strategy. This involves creating a legal framework in the divorce decree where extraordinary expenses must be agreed upon in writing before they are incurred. Without this, David could find himself suddenly responsible for 60% of a $5,000 summer coding bootcamp that he never approved. The curriculum provides templates for expense notification forms that David can use to ensure every dollar spent above the basic obligation is documented and justified. We must also look at the case study of the gig economy scrub. In 2026, many litigants have side hustles, selling on digital marketplaces, driving for autonomous delivery networks, or managing short-term rentals. The Divorce University warns that these are the first places an opposing attorney will look for hidden income. The curriculum teaches students how to perform a self-audit of their digital wallets. David is instructed to look at his 2025 Venmo and Cash App history. If he received $1,000 from a friend for a shared vacation, but it isn't labeled, a court might see that as unreported income. The university provides a categorization system to label every digital transaction, ensuring that reimbursements are not taxed as revenue in the support calculator. The complexity of 2026 child support also involves the parenting time offset. As we discussed in Part 4, Time is Money, many states use a formula where the more nights David has the children, the lower his cash support payment becomes. This is because he is presumably spending more on direct costs like food and utilities while the children are with him. The university provides David with a threshold analysis. If David has 127 nights, his support might be $1,000. If he reaches 128 nights, a different formula kicks in, potentially dropping his support to $700. This one-night difference represents a $3,600 annual swing. The university emphasizes the importance of a precision-engineered parenting calendar, teaching David how to use historical trends in holiday overnights to reach those critical thresholds. Finally, the university addresses the modification trap. In the U.S., child support is rarely set it and forget it. If David's income increases by a certain percentage, or if Sarah loses her job in 2027, either party can file for a modification. The 2026 curriculum teaches the protective filing strategy. If David loses his contract in June 2026, he is taught to file a motion to modify immediately. In many jurisdictions, The court cannot retroactively reduce support. If David waits until August to tell the court he lost his job in June, he is still legally obligated to pay the higher amount for those 2 months, even if he didn't have the money. The university provides a crisis filing kit for these exact scenarios. As David masters the spreadsheets, he realizes that the math of divorce is actually a language of leverage. He has moved from fear to a granular understanding of his financial destiny. But even with the numbers balanced, there is a final looming hurdle. All of this preparation, the digital audits, the vocational evaluations, the parenting calendars, is designed to avoid one specific thing, the courtroom. However, in 2026, a new trend is emerging where the educational model of divorce is being challenged by a litigation-heavy counter-movement. What happens when your spouse refuses to accept the data? What happens when the divorce university graduate meets a scorched earth attorney who wants to throw the spreadsheets out the window and let a judge decide based on character and emotion? In the next part, we are going to look at the mediation war room, the specific psychological and tactical strategies used in 2026 to force a settlement when the other side refuses to be rational. We will explore the high-conflict personality profile and how to use negotiation aikido to end the case without spending another year in the family court grinder. Are you ready to move from the spreadsheet to the negotiation table? The negotiation table of 2026 is no longer a mahogany desk in a wood-paneled law office. For the student of a divorce university, it is a high-definition digital interface where the battle is won by the person with the most disciplined emotional regulation and the most accurate data sets. To understand how this works in practice, we must follow the journey of Michael, a high-level architect based in Chicago. Michael is entering the mediation phase of his divorce in early 2026. His spouse, Linda, has hired a traditional scorched earth litigator, whose reputation is built on aggressive discovery and emotional provocation. In any other decade, Michael would be the underdog, facing a barrage of legal motions designed to drain his spirit and his bank account. But Michael has spent the last 6 weeks in the negotiation aikido module of his online divorce university, and he is about to transform the momentum of the entire case. The first lesson Michael mastered is the identification of the high-conflict personality, or HCP. Historical trends in family law indicate that approximately 20% of divorces account for 80% of the court's time, and these cases are almost always driven by an HCP. These individuals exhibit a pattern of blame shifting, all-or-nothing thinking, and unmanaged emotions. The Divorce University curriculum teaches Michael that you cannot bargain with an HCP using logic or appeals to fairness. Instead, you must use a strategy called the BIF response: brief, informative, friendly, and firm. Michael's curriculum includes a real-time simulator where he practices responding to aggressive emails from Linda's attorney. When the attorney sends a 3-page letter accusing Michael of hiding architectural fees in offshore accounts, a common provocation, the old Michael would have spent 4 hours writing a defensive, angry rebuttal. The university-trained Michael takes 10 minutes to write 3 sentences. We received your inquiry regarding the architectural fees. Attached are the 2024 and 2025 project ledgers, which show all payments were deposited into the joint marital account. Please let us know if you require further documentation by Friday at 5 p.m. By remaining informative and firm, Michael refuses to provide the emotional fuel the HCP needs to keep the conflict burning. As Michael prepares for his virtual mediation session in 2026, the university instructs him on the physical and digital setup of his war room. This is a step-by-step masterclass in environment control. Michael is told to use dual monitors, one for the video feed of the mediator and the other for his master asset spreadsheet. He is taught to maintain a poker face, even when the video is off, or when he is in a digital breakout room. The university provides a case study of a 2025 mediation where a spouse's reaction to a specific settlement offer was captured on a hot mic, leading to a loss of $10,000 in leverage. Michael learns the 5-second rule. Always wait 5 seconds after the other party finishes speaking before unmuting his microphone. This pause serves 2 purposes. It ensures the other person is actually finished, and it creates a psychological vacuum that often forces the other side to keep talking, potentially revealing their true bottom line. Now we enter the realm of negotiation aikido. In martial arts, aikido is the art of using an opponent's energy against them. In a 2026 divorce, this means using the anchoring effect. Historical trends in psychology show that the first number put on the table sets the anchor for the rest of the negotiation. However, The university teaches Michael a dynamic anchoring strategy. Instead of Michael being the one to throw out a number, he uses calibrated questions to force the other side to anchor themselves. He asks, "How am I supposed to agree to a 50-50 split of the equity when the data shows 60% of the down payment came from my premarital inheritance?" This forces Linda's attorney to defend their position against a hard data point. The curriculum then moves to the settlement pressure matrix. In 2026, the U.S. court system is still dealing with a massive backlog from the previous years. The university provides Michael with a time-cost analysis report specifically for Cook County, Illinois. This report shows that if they don't settle in mediation today, the next available trial date is 14 months away. Michael is taught to subtly introduce this historical trend into the conversation. He isn't threatening. He is simply stating a logistical fact. By showing the other side that a trial will cost both parties an additional $30,000 in legal fees and 14 months of life stagnation, Michael makes the mediated settlement look like a massive victory for everyone involved. Imagine if Michael were doing this without the university. He would be at the mercy of his attorney's billing cycle. Instead, Michael is using the university's drafting the first version strategy. This is one of the most powerful tactics in the 2026 divorce university syllabus. The curriculum argues that the person who writes the first draft of the settlement agreement has a massive structural advantage. They get to define the definitions, set the timelines for asset liquidation, and choose the default language for future disputes. The university provides Michael with a standard marital settlement agreement template that is pre-coded with mediator-approved clauses. When the mediator asks who should take the first crack at the written agreement, Michael's hand goes up immediately. By the time Linda's attorney receives the draft, the frame of the deal has already been established. Furthermore, we must analyze the BATNA, or the best alternative to a negotiated agreement. This is a core concept in Harvard negotiation theory, but the divorce university has modernized it for the 2026 demographic. Michael's BATNA is a detailed spreadsheet showing exactly what a judge in his specific district is likely to do, based on recent case studies from 2024 and 2025. This gives Michael quiet confidence. He knows exactly when to walk away from the table. If Linda demands 80% of the retirement account, Michael knows his BATNA, the likely court outcome, is 50%. Because he is educated, he doesn't get scared by the attorney's bluster. He simply says, "That proposal doesn't align with current historical trends in this district. Perhaps we should let the judge decide in 14 months." This willingness to walk away, backed by data, is the ultimate leverage. Another fascinating 2026 trend the university explores is online dispute resolution, ODR software. Some divorce universities are now integrating AI-driven blind bidding modules. In this scenario, Michael and Linda would both enter their secret numbers for the value of the family business into a secure portal. If the numbers are within a certain percentage of each other, say 10%, the software automatically splits the difference and settles the issue instantly. This removes the ego from the valuation. Michael is taught how to use these double-blind tools to settle the small, annoying items that usually derail a mediation, like the value of household furniture or the division of a shared wine collection. As Michael nears the end of the mediation, he encounters the final 5% module. Historical trends show that most mediations fail in the last hour over a tiny fraction of the total estate. The university teaches Michael the trade-off technique. He is instructed to hold back a few small concessions throughout the day. When the negotiation stalls over who gets the $5,000 tax refund, Michael generously gives it up in exchange for the other party signing off on the no alimony clause he actually cares about. This is the art of trading pennies for dollars. But even with a signed agreement, the work is not over. In the 2026 U.S. demographic, a signed settlement is just a piece of paper until it is executed. And this is where the post-mediation minefield begins. What happens when the spouse refuses to transfer the funds? What happens when the house won't sell in the 2026 real estate market? What happens when the educational model has to turn into an enforcement model? In the next part, we are going to dive into the implementation phase. The specific steps the divorce university teaches to ensure the money actually moves, the deeds are actually signed, and the hidden liens of the 2026 economy don't swallow your settlement whole. We will explore the asset transfer checklist that prevents buyer's remorse from turning into a new lawsuit. Are you ready to see how the paper victory becomes real wealth? The paperwork is where the fantasy of a clean break meets the friction of the administrative state. In the 2026 Divorce University curriculum, this stage is known as the execution of the decree. For many Americans, receiving a signed judgment from a judge feels like the finish line, but historical trends suggest that 40% of post-divorce litigation stems from a failure to properly implement the terms of the settlement. To illustrate the high stakes of this phase, let us look at the case of Marcus, a fitness franchise owner in Orlando, Florida. In 2026, Marcus finalized a settlement that allowed him to retain his business and the primary marital residence in exchange for a structured buyout of his ex-spouse's equity. On paper, Marcus won. In reality, he was entering a 6-month logistical gauntlet that would test his financial literacy to its limits. The first item on the Divorce University asset transfer checklist is the decoupling of real estate. In the U.S. demographic of 2026, home equity often represents over 60% of a household's net worth. Marcus was required to remove his ex-spouse's name from the mortgage while simultaneously paying out $200,000 in equity. The university's real estate optimization module taught Marcus that a simple quitclaim deed is not a financial shield. While the deed transfers ownership, it does not remove the liability for the debt. Marcus learned that if he didn't refinance the loan into his name alone, his ex-spouse's credit would remain tied to the property, and she could technically be held liable for the payments if he defaulted. However, in the interest rate environment of 2026, a traditional refinance was mathematically devastating. Marcus was looking at jumping from a 3% historical rate to a much higher current market rate, which would have increased his monthly overhead by $1,500. The university provided Marcus with a case study on the mortgage assumption. This is a rarely used but critical tool where the lender allows one spouse to take over the existing loan terms. Marcus learned how to navigate the qualified assumption process, which involved a rigorous credit check and a specific application to the bank's loss mitigation department. By successfully assuming the loan rather than refinancing, Marcus saved tens of thousands of dollars in long-term interest payments. This is the kind of granular money-saving detail that justifies the enrollment in a digital university for a modern pro-se litigant. The second pillar of the implementation phase is the QDRO, or the Qualified Domestic Relations Order. For Marcus, this involved splitting a significant 401k account. The Divorce University taught him that a divorce decree by itself is legally insufficient to move retirement funds without triggering massive tax penalties and early withdrawal fees under the Internal Revenue Code. Marcus had to follow a 3-step protocol provided by the curriculum. First, he had to obtain the summary plan description from his employer's HR department to find the specific requirements for their plan. Second, he used the university's QDRO template to draft an order that met both the court standards and the plan administrator's internal rules. Finally, he learned the importance of the pre-approval. By sending the draft to the plan administrator before presenting it to the judge, Marcus avoided the common historical trend of having a signed court order rejected by a bank 3 months later, which usually requires a costly return to court. But Marcus's case became even more complex when it came to his fitness franchise LLC. In the 2026 U.S. economy, small business owners face unique challenges during asset transfers. The Divorce University curriculum on business interest transfers focused on Section 1041 of the Internal Revenue Code, which allows for tax-free transfers of property between spouses incident to a divorce. Marcus learned that he needed to update his operating agreement and issue new membership interest certificates. He also had to ensure that the intangible goodwill of the business was properly accounted for so that the transfer didn't trigger an unexpected gift tax or capital gains event. The university provided a step-by-step guide on how to file a Form 709 if necessary, though the primary goal taught was to keep the transaction within the 1041 safe harbor. Then came the issue of the hidden lien. The Divorce University warned students that in 2026, digital footprints and automated credit reporting mean that any unpaid joint debt can instantly attach to your newly separate assets. Marcus discovered a joint credit card from 2024 that had a lingering balance he wasn't aware of. The curriculum taught him the account closure and reissue protocol. This involves more than just paying the bill. It requires sending a certified letter to the creditor stating that the account is to be closed to further charges and that the parties are moving to separate liability. Without this, even after the divorce, one spouse could potentially run up the card, and the bank, which is not a party to the divorce decree, could still pursue Marcus for the full amount. We must also look at the digital asset handshake. For the 2026 demographic, This includes everything from cryptocurrency wallets to shared cloud storage and family plan streaming services. Marcus had to transfer a portion of his digital asset portfolio to his ex-spouse. The university provided a security protocol for this, the escrow handshake. Rather than sending the funds directly to a private wallet where a typo could result in a total loss of funds, they used a multi-sig wallet where the transfer was only finalized once both parties verified the receipt of a small test transaction. This technical education prevented a potential $50,000 mistake that a traditional attorney might not have the technical expertise to manage. As Marcus moved through the checklist, he encountered the final and most difficult module, the enforcement of non-compliance. What if, despite the signed agreement, the ex-spouse refuses to sign the car title or vacate the house? The Divorce University teaches the ladder of escalation. It starts with the gentle reminder template, moves to the formal demand for performance, and ends with the motion for contempt. Marcus learned that in many U.S. jurisdictions in 2026, if you have to file a motion to enforce a clear term of the decree, the court may order the non-compliant party to pay your attorney fees or a daily fine. By showing his ex-spouse the potential outcomes of her delay using these case studies, Marcus was able to secure her signature on the final documents without ever having to step foot back in a courtroom. The success of Marcus's implementation phase was not an accident. It was the result of treating the end of his marriage as a corporate divestiture. He realized that the paper victory of the divorce decree was only the beginning of his financial independence. But even with the assets transferred and the titles cleared, Marcus faced a new, psychological and economic challenge. He was now a single individual in a 2026 economy designed for dual-income households. He had to learn how to rebuild his credit, recalculate his tax withholdings as a single filer, and re-enter the dating market with a digital prenup in hand. This brings us to the next phase of our deep dive. The Divorce University doesn't just teach you how to get out, it teaches you how to stay out of the financial hole. In the next part, we are going to look at the post-divorce financial rebuild. We will examine how the 2026 demographic is using credit repair algorithms to bounce back from the hit of a divorce, the tax brackets of the single parent, and the rise of the divorce insurance market. How do you protect your new wealth from the next relationship? We are going inside the world of second chance financial planning. Are you ready to see what life looks like after the decree is finalized? The decree is signed, the accounts are split, and for the first time in years the legal notifications have stopped. But for Marcus in Orlando, the silence of his home is punctuated by a new kind of anxiety, the realization that his financial identity has been halved. In the 2026 American economy, a solo income is a precarious foundation, and the Divorce University curriculum for Part 8, titled The Phoenix Protocol, focuses on the high-speed reconstruction of a solo financial profile. Historical trends show that the 12 months following a divorce are the most critical for long-term wealth stability. Marcus is not just starting over. He is launching a recovery mission in a digital economy that remembers everything and forgets nothing. The first obstacle Marcus faces is the credit score paradox. When Marcus and his ex-spouse closed their joint credit cards to finalize the asset division, his credit score plummeted by 60 points in a single month. This was not because of missed payments, but because of the sudden reduction in his total available credit and the shortening of his average account age. In 2026, your credit score is your passport to the world. Without a top-tier score, Marcus cannot refinance the gym equipment for his fitness franchise or secure a favorable rate on a new vehicle. The Divorce University curriculum teaches a technical workaround known as the digital credit infusion. Marcus is instructed to open 2 high-limit, low-fee secured cards immediately, but the university takes it a step further. It teaches him how to use his recurring utility bills, electricity, water, and even his high-speed internet to report directly to the credit bureaus through 2026-era financial apps. Historical case studies show that for a single-income household, this non-traditional data reporting can boost a score by 30 points in 90 days. Marcus also learns the authorized user strategy. He asks his elderly father, who has a perfect credit history since the 1980s, to add Marcus as an authorized user on a long-standing account. Marcus doesn't even need the physical card. He just needs the decades of perfect payment history to reflect on his solo report. This is a step-by-step masterclass in credit engineering that prevents Marcus from being sidelined by the very system he just fought to navigate. Next, the university dives into the tax brackets of the single parent. In 2024 and 2025, Marcus and his spouse benefited from the married filing jointly status. In 2026, Marcus is staring down the single filer tax table, which has much narrower brackets. However, the university reveals the head of household loophole. If Marcus has his children for at least 183 nights a year and pays for more than half the cost of keeping up the home, he qualifies for a much larger standard deduction and more favorable tax rates. But there is a catch that the university highlights through a case study of a 2025 tax audit. Marcus must have a paper trail to prove he paid for more than 50% of the household costs. The curriculum provides Marcus with a monthly expense tracker that categorizes rent, groceries, and utilities specifically for IRS compliance. He learns that in 2026, the IRS uses automated algorithms to flag single parents who claim head of household status if their reported income doesn't align with the local cost of living. By maintaining a digital tax vault, a folder containing every receipt and utility bill from 2026, Marcus ensures that his tax savings of $4,000 a year are protected from future litigation or audits. The most daunting task for Marcus, however, is the retirement gap. After the QDRO we discussed in Part 7, Marcus's 401k was reduced from $400,000 to $200,000. At age 45, he is facing a 20-year horizon to rebuild. The Divorce University's Second Chance Financial Planning module introduces the HSA Triple Tax Advantage. Marcus is taught to switch to a high-deductible health plan for his fitness franchise employees and himself. He can then contribute to a health savings account, where the money goes in tax-free, grows tax-free, and comes out tax-free for medical expenses. The university teaches him to treat the HSA as a stealth IRA. By paying for current medical expenses out of pocket, and letting the HSA invest in total market index funds, Marcus can potentially recapture 20% of his lost retirement wealth through tax efficiency alone over the next decade. Now imagine it is late 2026. Marcus is finally feeling stable. He enters the dating market, which has changed radically since he was last single 15 years ago. In the modern U.S. demographic, dating after divorce involves a high degree of financial transparency. This is where the university introduces the digital prenup and the cohabitation agreement. Marcus meets Chloe, a successful digital marketing executive. They begin a serious relationship. In 2026, the historical trend of common law marriage, or palimony claims, is on the rise in several U.S. states. If Chloe moves into Marcus's home, which he fought so hard to keep, she could potentially claim an interest in the property's appreciation after a few years. The Divorce University provides Marcus with a lifestyle protection framework. Before Chloe moves in, they sign a cohabitation agreement. This document clearly outlines that Marcus's home remains his separate property, and Chloe's contributions to the shared household expenses are considered rent rather than an investment in equity. This isn't about a lack of trust. It is about the business of living in 2026. The university teaches Marcus how to have the money talk without killing the romance. They call it the Financial Disclosure Exchange. Marcus and Chloe sit down with their laptops and swap financial CVs, summaries of their debts, assets, and credit scores. This level of radical transparency is a hallmark of the post-divorce demographic. It prevents the second divorce disaster, where individuals rush into a second marriage only to realize their new partner has significant undisclosed debt or a high-conflict litigation history. Furthermore, the university explores a new 2026 product, divorce litigation insurance. These are contingency funds or insurance policies that people can buy to cover legal fees in the event of a future dispute. While Marcus doesn't buy a policy, he uses the university's advice to set up a litigation sinking fund. He diverts $200 a month into a high-yield savings account designated specifically for family law contingencies. Historical trends suggest that post-decree disputes over child support or custody modifications occur in 30% of cases within the first 5 years. By having $5,000 set aside, Marcus ensures that a future legal threat won't bankrupt his business or force him into a predatory loan. As Marcus completes the Phoenix Protocol, he realizes that the Divorce University has changed his fundamental relationship with money. He no longer sees his finances as a shared, amorphous cloud. He sees them as a fortified citadel. He has rebuilt his credit, optimized his taxes, and protected his future relationships with legal safeguards. He is a smarter, leaner, and more resilient version of the man who walked into the attorney's office in Part 1. But there is one final test. As Marcus looks at his children, He realizes that the most important legacy he can leave is not just the money he saved, but the divorce-proofing of the next generation. In 2026, U.S. demographics show a rising trend of intergenerational divorce contagion, the idea that children of divorce are statistically more likely to experience it themselves. The university's final modules aren't about spreadsheets. They are about the cultural legacy of the split. In the next part, we are going to look at the psychology of the 2026 co-parenting unit. We will explore how Marcus uses AI-driven parenting tools to maintain a parallel parenting model that shields his children from conflict. We will dive into the digital legacy vault for the kids and how to handle the wealth transfer in a split family to ensure the children are the ultimate beneficiaries of the divorce university strategies. How do you turn a broken home into two healthy, thriving hubs? Are you ready to master the soft skills of the 2026 Divorce University? The shift from financial reconstruction to the architecture of a stable childhood is the most profound cognitive transition Marcus undergoes in the 2026 Divorce University curriculum. This module, titled The Architecture of Two Hubs, moves away from the aggressive litigation mindset and toward the creation of a sustainable co-parenting ecosystem. In the modern U.S. demographic, where nearly 50% of children will spend part of their lives in a single-parent or blended household, the goal is no longer just surviving the split. It is about thriving in a dual-home reality. Historical trends in developmental psychology suggest that the primary predictor of a child's long-term success post-divorce is not the split itself, but the level of ongoing conflict between the parents. The 2026 university curriculum teaches Marcus that his job is now to become a professional border agent between his world and his ex-spouse's world. The first strategy Marcus masters is the parallel parenting model. This is a specific educational framework designed for high-conflict or medium-conflict pairs where traditional, collaborative co-parenting has historically failed. Imagine Marcus and his ex-spouse in a situation where every phone call leads to a disagreement about extracurricular activities or discipline. In the 20th century, this would lead to constant court motions. In 2026, the university teaches Marcus to implement communication silos. This involves a step-by-step process of moving all interaction to a court-approved digital interface. The curriculum provides a guide on setting up parallel workflows where Marcus and his ex-spouse each have total autonomy over their respective households. The university uses case studies to show that by reducing the number of required joint decisions to the absolute minimum, such as major medical or educational choices, the overall stress on the children is reduced by up to 60%. Next, the curriculum introduces the AI sentiment filter for parent communication. In 2026, the tools provided to pro-se litigants include advanced natural language processing. Marcus learns how to run every message he writes through a conflict reduction algorithm. The university provides a case study of a father in California who used this technology to transform a hostile relationship. When Marcus wants to write a message complaining about a late drop-off, the AI flags the aggressive tone and suggests a data-based alternative. Instead of saying, "You are always late and disrespectful of my time," the tool suggests the 6 p.m. drop-off was missed. For the kids' routine, can we align on a 6:15 p.m. window moving forward? Historical trends in 2026 show that parents who use these sentiment filters are 70% less likely to end up back in court for contempt of communication charges. The university then dives into the digital legacy vault for the children. In the modern U.S. demographic, a child's life is documented across school portals, medical apps, and social media. Marcus is taught that in a split household, the loss of information is a form of neglect. The curriculum provides a step-by-step technical guide for creating a shared information repository. This is a secure digital vault where both parents have read access to the children's immunization records, report cards, and therapy notes. Marcus learns to automate the syncing of these records. For example, he sets up a rule where any email from the school's parent portal is automatically forwarded to the vault. This removes the need for Marcus to ask his ex-spouse for information, which is a historical flashpoint for conflict. By automating the data flow, Marcus ensures that both homes are operating with the same information set, creating a sense of consistency for the children. One of the most critical financial components of the soft skills module is the 529 College Fund Security Protocol. In 2026, with the cost of a 4-year degree at a private university projected to exceed $400,000, these funds are high-value targets. Marcus learned in the earlier modules that his ex-spouse could potentially liquidate or change the beneficiary of a 529 plan if they are the sole owner. The university's 2026 curriculum provides a case study on the dual signature restrictive covenant. Marcus is taught how to petition the court to require both parents' signatures for any withdrawal from a college savings account. He also learns how to set up successor owner designations to ensure that if something happens to one parent, the fund remains protected for the children and doesn't pass to a new spouse or an estate. This leads directly into the module on the bloodline trust and estate planning for split families. Marcus is 45 and he is rebuilding his wealth. He is taught that in the event of his death, if he simply leaves everything to his children, and they are minors, his ex-spouse, as their legal guardian, could potentially control those assets. The Divorce University provides a masterclass on the discretionary spendthrift trust. This legal structure allows Marcus to name a neutral third party, such as a professional trustee or a trusted sibling, to manage the money for the children's benefit until they reach a certain age. The curriculum explains that this protects the inheritance from being used for the ex-spouse's personal expenses or from being entangled in a future step-parent's debts. This is a case study in intergenerational wealth protection, ensuring that the financial sacrifices Marcus made during the divorce are not erased by future domestic complications. Furthermore, the university addresses the social dynamics of 2026. Marcus is taught how to handle the first right of refusal in a digital age. This is a clause that says if one parent cannot watch the kids for a certain period, say 4 hours, they must offer that time to the other parent first. In the past, this was a source of constant spy-like behavior. The university provides a 2026 approach, the integrated scheduling algorithm. Marcus uses an app that tracks his work travel and automatically triggers a notification to his ex-spouse if a business trip overlaps with his parenting time. By making the process algorithmic, it removes the ego from the request. It becomes a logistical notification rather than a personal negotiation. The final soft skill taught in Part 9 is the divorce proofing of the children's financial literacy. The university argues that children who see their parents manage a divorce with data-driven maturity are more likely to develop a healthy relationship with money themselves. Marcus is taught to be transparent with his kids, at an age-appropriate level, about the cost of the two homes. He doesn't blame the other parent. He simply teaches them about budgeting, the value of the 529 plan, and why mom's house and dad's house might have different financial rules. Historical trends suggest that this transparency reduces the loyalty binds that children often feel and empowers them to be financially independent adults. As Marcus completes this module, he sees that he has built more than just two separate lives. He has built a resilient, decentralized family structure. He has used the 2026 Divorce University to move from a state of total domestic collapse to a position of systemic stability. But as he looks toward the horizon, there is one final, overarching question that every student of the university must answer. We have analyzed the assets, the math, the negotiation, and the parenting. But what is the ultimate cost of this new educational approach to heartbreak? In the final part of our deep dive, we are going to look at the big picture of the divorce university industry. We will analyze the 2026 market data on whether these platforms are actually reducing the divorce rate or simply making the process more efficient. We will look at the rise of the professional divorce consultant and the future of the family court in an era of AI and digital sovereignty. Is the classroom model of divorce the ultimate solution? Or is it the start of a new, even more complex legal arms race? Get ready for the final synthesis of the modern American divorce. The legal arms race of 2026 has officially moved from the courtroom to the server room. As we reach the final synthesis of this deep dive, we must acknowledge that the classroom model of divorce is not just a trend. It is a fundamental restructuring of American civil society. To understand the magnitude of this shift, we look at the macro-level market data for 2026. For the first time in U.S. history, the number of pro-se litigants, individuals representing themselves, has surpassed 65% in family court jurisdictions across the Sun Belt and the Pacific Northwest. This is not because people are becoming more litigious, but because the cost of entry for high-level legal information has dropped from a $5,000 retainer to a $500 subscription. This democratization of data has created a new demographic, the professionalized pro se litigant. Imagine the landscape of a typical family court in 2026. 10 years ago, a judge would look down at a self-represented individual and see a person likely to make procedural errors, emotional outbursts, and logistical blunders. Today, that same judge sees someone like Marcus, who enters the room with a university-issued trial notebook, a data-backed evidence matrix, and a calm administrative demeanor. The historical trend shows that when both parties are educated through these online platforms, the time to reach a final decree is reduced by an average of 8 months. However, this efficiency comes with a new set of complexities. We are entering the era of the algorithmic settlement. In 2026, the advanced modules of the Divorce University include what is known as predictive judicial modeling. These platforms have aggregated millions of data points from public court records across all 50 states. Marcus doesn't just guess how a judge in Orange County might rule on his fitness franchise valuation. He runs a simulation. The software analyzes the last 5 years of that specific judge's rulings on small business assets and provides a range of potential outcomes. This effectively removes the gambler's fallacy from the divorce process. When both sides have access to the same predictive analytics, the incentive to fight it out in court diminishes. If both Marcus and his ex-spouse know the computer predicts a 50-50 split with 90% certainty, spending $30,000 to argue for 60% becomes a mathematically irrational decision. This leads to the rise of what sociologists call the cold peace. In the 2026 U.S. demographic, we are seeing a decline in the scorched earth divorce and a rise in the surgical separation. These online universities are teaching people to treat their marriages like a failed business partnership that needs an orderly liquidation. But what does this do to the legal profession? The data shows a massive pivot in the business model of family law firms. In 2026, lawyers are increasingly offering unbundled legal services. Instead of taking over the whole case, they act as high-level consultants for Divorce University students. Marcus might pay a lawyer for a 1-hour strategy session, to review his self-drafted decree, or to handle a specific high-stakes deposition. This gig economy approach to law allows the middle class to access elite legal minds without the crushing weight of a full-scale billable hour model. But there is a darker side to this educational arms race that we must analyze. What happens when the educational model is used by a bad actor? In 2026, some platforms have been criticized for teaching gray area tactics, legal maneuvers that are technically allowed but designed to cause administrative friction. For example, a student might learn how to file a request for production that is so voluminous it effectively freezes the other party's ability to move forward. This is the digital filibuster. As these universities become more sophisticated, the family court system is being forced to implement its own AI-driven gatekeeper protocols to flag and dismiss these tactical abuses of the self-taught litigant. Let's look at the demographic dividend of the 2026 Divorce University. Case studies show that the group benefiting most is the missing middle, households earning between $80,000 and $160,000. These are the Americans who, in 2024, were often bankrupted by the legal process, losing their homes just to pay for the fight over who got to keep them. In 2026, this demographic is using online education to preserve their net worth velocity. By spending less on the process, they have more capital to reinvest in their solo lives. We are seeing a historical trend where the post-divorce poverty gap is narrowing, particularly for women in the 30 to 45 age bracket, who are now using these universities to secure more accurate child support and asset distributions without the legal tax of the past. Furthermore, we must consider the impact on the marriage market itself. The 2026 Divorce University has a pre-marriage track that is becoming a viral sensation among Gen Z. This demographic is using the data of divorce to pre-bunk their future relationships. They are learning about the legal reality of cohabitation before they even move in together. They are drafting digital asset agreements before they buy their first Bitcoin together. The university model is moving marriage from a romantic leap of faith to an informed strategic alliance. This shift is fundamentally changing the U.S. demographics' approach to commitment, leading to later marriages but statistically more stable ones, as the participants enter with a manual for the end already in their mind. As we synthesize all 10 parts of this masterclass, we see that the 2026 Divorce University is more than just a collection of videos. It is a paradigm shift. It represents the transition from the secret language of lawyers to the transparent logic of data. Marcus, our architect from the previous parts, is the face of this new era. He didn't just get a divorce, he completed a course in high-stakes asset management and domestic logistics. He emerged with his credit intact, his relationship with his children protected, and his business preserved. He is a graduate of a system that favors the prepared over the emotional. But as the classroom model becomes the standard, we must ask, are we losing the human element of justice? In a world where an algorithm predicts your custody schedule and a sentiment filter writes your emails, is there room for forgiveness or nuance? The 2026 demographic is trading emotional closure for administrative efficiency. For many, this is a trade they are more than willing to make. The family court grinder is being replaced by a digital dashboard, and while the heartbreak remains the same, the financial and logistical carnage is being mitigated by the power of education. The evolution of the U.S. divorce university is just the beginning. As we look toward 2027 and beyond, the next frontier isn't just how we end relationships, but how the state itself will adapt to a population that no longer needs a courtroom to find the truth. The data is clear. The era of the informed litigant is here, and the information monopoly of the legal elite has officially collapsed. This concludes our deep dive masterclass on the 2026 Divorce University and the modern U.S. demographic. But this is just one piece of the puzzle in the new American economy. While we have mastered the logistics of the split, a new, even more complex shift is occurring in the way Americans build wealth together in the age of decentralized finance. Are you ready to see how the next generation is using these same university models to create digital communes and microeconomies that bypass traditional banking entirely? The revolution isn't just happening in the courtroom. It is happening in the way we define family and capital in the digital age. The loop is open, and the next chapter of the American demographic shift is about to begin.